Spider-Man, what a remarkable hero. Kids love him. So does the High Court of Delhi apparently. Just a few days ago, Justice C. Harishankar passed an order restraining 101 rogue websites from streaming or making available to the public on their websites or through the internet any program or content in which Sony Pictures Animation Inc. had copyright, including the film Spider-Man Across the Spider-Verse and Spider-Man Into the Spider-Verse. Further, the court directed the internet service providers to block access to the 101 rogue websites, as well as any mirror websites which appear to be associated with any of the rogue websites. This order was passed in a case filed by Sony against websites which were making the movie Spider Man Across the Spider Verse available for viewing without obtaining a license or copyright from Sony for the same. Sony claimed that these websites were rogue websites, as has been defined earlier by the Delhi High Court in the case of UT Software Communication Limited versus 1337X.2TO. And thus Sony sought a decree of permanent injunction from the court restraining the rogue websites and any other mirror websites spawning from them from streaming or making available the film Spider-Man Across the Spider-Verse and Spider-Man Into the Spider-Verse to the public. Sony also sought that the internet service providers, which were parties to the case, be directed by the court to block access to the websites. I'll explain what are rogue websites very soon. As I explained in the last episode of this video series, in suits for IP related reliefs, parties also seek a temporary injunction or a restraining order against the party allegedly infringing the IP rights from carrying on their infringing activities till the time that the case is finally decided. This is done to prevent more loss while the case is still pending. Cases may take several years to be finally decided. A separate interim application is filed along with the main case for such interim reliefs or injunctions. In this particular case, Sony sought the same reliefs as it had in its main case that I had just discussed, temporarily, till final adjudication, in its interim applications as it did in the main case. These reliefs were thus granted by the court temporarily. Now let me tell you about the UTV software case and rogue websites. The UTV software case laid the foundation for the kind of relief that the court granted in this Spider-Man case to Sony. That is, identification of the websites as rogue, their blocking, and blocking of mirror websites. While taking you through the UTV software case, I'll also explain to you what the court said in it about online piracy and combating the same. I'm sure you will find it to be fun and interesting. UT software judgment was given by Justice Manmohan of the Delhi High Court. So in the UTV software case, the plaintiffs were makers of cinematographic films and had filed the suit against four classes of defendants. Plaintiffs means a party which files a civil case. Defendant means a party against whom a civil case is filed. First class consisted of identifiable websites that were distributing the films without any license, authorization, or copyright from the owners of the copyrights in the films. These defendants included some famous websites which you probably used back in the day to watch pirated movies online, such as Pirate Bay, F Movies, B Movies, and Extra Torrent. Second class of defendants consisted of John Doe defendants. The term John Doe means a party to a case whose identity is not known. John Doe defendants in this case were unknown parties that were engaged in unauthorized communication of the plaintiff's copyrighted works. These included persons who registered to the defendant's websites, persons who uploaded the copyrighted works on the defendant websites, and creators of redirect and mirror websites. Mirror website means a replica of a website. Third class of defendants included internet service providers, which provided access to these websites. The fourth class of defendants were government departments and agencies that were made parties to the case so that the court could give them directions to assist the internet service providers to curb the menace of piracy, which included harming the business of the producers of the movies. And this included the Department of Telecom and the Ministry of Information and Technology. So, this was an ex parte case. This means that none of the defendants appeared. Only the plaintiffs and an amicus curiae, which means a lawyer appointed by the court to assist it due to the special nature of the subject matter, made their arguments. They took the court through the complexities of the issues involved, laws and policies of different countries on piracy, possible legal solutions, and their implementability. Now, let me tell you about the court's findings in this case, which essentially form the foundation for reliefs granted in the Spider Man case and similar cases. The court found that there was sufficient evidence to show that digital piracy had caused significant damage to the film industry and that it had a real, tangible impact which could be felt by the owners of the films. The court discussed how websites like BitTorrent had made the cross border digital piracy easy and how it had led to a decline in the revenues of copyright owners of films. Estimated that by the end of 2022, unabated film piracy would lead to global revenue losses of up to $644 billion. And that's a staggeringly high figure, if you ask me. Court also pointed out very rightly that digital piracy not only harms the rights of big film producers, but also new and struggling artists and creators and all the persons employed or engaged in the filmmaking process, such as designers, editors, technicians, and the persons involved in marketing and sales of the films. The court then discussed the existing remedies provided by the Golden Statute for Creators, the Copyright Act, and explained how it provided protection to cinematographic films. The court held that the websites were liable under Section 51A2 of the Copyright Act, as this section imposed liability on persons who allowed their plays to be used for communication of a film to the public without the authorization of the owner of the copyright in the film. The court also held that the websites were not intermediaries and that they only stored the films incidentally or transiently and thus could not escape liability, right? So what the court said is that they were not intermediaries. An intermediary is an entity which only stores content, incidentally or transiently in the process and does not actually create the content. But in this case, the websites were held not to be intermediaries. And the court then said that the plaintiffs had the right to approach the court for injunctions under Section 55 of the Copyright Act. Now I'll come to the most interesting aspect that the court discussed. The court examined whether an infringer of intellectual property rights on the internet should be treated differently from an infringer in the physical world. The court discussed the school of thought of internet exceptionalists, such as Electronic Frontier Foundation, which believes that since the internet is exceptional, the rules that apply to the physical, real world should not apply in the online world. They firmly believe that the internet's very existence is to liberate individuals from state control and that it is about individual freedom, not collective responsibility. They, in fact, even say that the piracy may hurt the sales of firms and corporations, but it benefits consumers who get free content. So the court then went on to vehemently reject this absurd school of thought and said that piracy websites are in it not for such ideologies, but only for money. The court cited records from other countries to show the huge revenues that piracy websites were making. So Pirate Bay was making $3 million a year, and Kickass Torrents was making $16 million a year just from advertisements on it. The court explained that the major chunk of revenues made by these piracy websites was in fact from ads on their platform. It held that if the school of thought of exceptionalists was followed, it would lead to lawlessness and all criminals would simply shift online for immunity. So the court found that combating piracy does not in any way restrict an open and free internet. Thank God for this rational school of thought adopted by the Honorable High Court of Delhi. I personally can't digest the thought of anarchists, which promote absolute lawlessness. They're the same people who think that a free and open internet means letting child pornography and cyber terrorism have a free run. The court then discussed what a rogue website is. It said that a rogue website is one which mainly shares infringing or pirated content. It either streams it either streams the pirated content itself or provides links to third-party websites which provide the pirated content. The court then listed a number of factors which indicate that a website is indeed a rogue website. I'll tell you about a few of the important ones. One is whether the main purpose of the website is to commit or facilitate copyright infringement. Other, interestingly, is whether it makes users and registrants of the website untraceable. Then, whether the website remains silent even after receiving takedown notices for infringing content. And also, whether access to the website has been disabled by orders from another court in another territory. And lastly, whether the website provides instructions or tips to evade legal restrictions to access the pirated content. The court clarified that this is not an exhaustive list, meaning that there may be more factors indicating that a website is a rogue website, and neither is it necessary nor that all of these boxes need to be ticked for a website to be considered rogue. The court also noted how difficult it is to tackle piracy on an international level, and in cases where the host website is in another country where the intellectual property enforcement is weak. Finally, the court found that blocking of the entire website was the only effective remedy and not blocking of only specific infringing URLs, as it was very easy for pirates to simply make new URLs and keep on distributing pirated content. The court found that in the interest of curbing illegal pirated content, blocking of entire websites that were rogue in nature would not be a violation of free speech on open internet. Lastly, the most special part of the judgment was the relief given. The court gave the first dynamic injunction in this case, which set the ball rolling for future injunctions, such as that in the Spider Man case. This means that not only were the rogue websites blocked by the court's orders, through its directions to the internet service providers and government bodies, the plaintiffs were even given permission to implement any new mirror website that would crop up showing the pirated content, for which a simple blocking order by the registrar would be given upon finding that it indeed is a mirror website of the rogue website, without having to go through the tedious process of adjudication by the court itself. So that's all about rogue websites, their history, first dynamic injunction in the UTV software case, and similar orders being given now in cases such as the Spider Man case. I hope you enjoyed today's episode and found it useful. Stay tuned for more exciting episodes on my show. Do subscribe to my channel if you like the content and want to watch more of it. Thank you.